Simpkins from the New South Wales Law Enforcement Conduct Commission to talk about consorting laws.
Good afternoon, everyone. To start, I'd like to acknowledge the Gadigal people of the Eora Nation, who are the traditional custodians of the lands we meet on today and the waters glistening in the bay outside. And I pay my respect to their elders, both past and present, and all First Nations people joining us today. Today I'm going to highlight the Law Enforcement Conduct Commission's recent legislative review of the consorting law in New South Wales. Specifically, given the focus on this session is on young people, I'll be looking at the issues we identified in relation to the use of consorting laws on people under 18. The report contains analysis of the uses across the whole community, so feel free to check it out if you're interested in our observations on other cohorts. So I'll take you through the Commission's legislative review function, some definitions around consorting, how we did the review, the results of our analysis in relation to the use of consorting law on children and the issues we identified, and our recommendations and the responses from the New South Wales Police Force. In particular, we'll look at some of the Commission's concerns around the use of consorting law in capturing and criminalising associations that were not clearly related to serious or organised crime, and the potential for this to increase a child's interactions within the criminal justice system. I'll also cover some of the Commission's concerns about the way consorting warnings were issued to young people, including the predominant use of verbal warnings in circumstances where children may not properly understand the warning that's issued to them. But first, a little bit about the Law Enforcement Conduct Commission. The Commission is the independent police watchdog in New South Wales. Our jurisdiction also extends to the New South Wales Crime Commission. The Law Enforcement Conduct Commission was set up to strengthen law enforcement integrity by detecting, investigating and preventing misconduct and maladministration within law enforcement in New South Wales. Our core functions are to oversight the handling of misconduct investigations by the New South Wales Police Force and Crime Commission, and to detect and investigate allegations of serious misconduct by police and Crime Commission officers. We independently oversight and monitor the investigation of critical incidents by the New South Wales Police Force, and we undertake research projects and investigations that focus on systemic misconduct and maladministration issues, such as conduct or practices that might be unreasonable or unlawful, with a view to assisting the New South Wales Police to address and prevent such misconduct. But the work I'm going to talk about today is a little bit different. It arises from our legislative review function. So from time to time, Parliament asks the Commission to review the way police exercise particular powers and to report publicly about our analysis. We might be asked to do this when police are given new powers or when Parliament wants to observe how particular powers work in practice. This work is not about identifying misconduct or addressing misconduct, but it is about independent scrutiny of police practice. When we do this work, we look at whether police practice conforms with the legislation. We look at the way police are trained and the way their procedures and policies explain what officers must do. We look at the impact of the police practices on the community and particularly more vulnerable groups within the community. And generally we describe the way police powers are exercised. So essentially just keeping those powers under scrutiny. Earlier this year, hang on, let me just double check that. Yep. Earlier this year, we reported on our review of recent amendments made to the consorting laws. These laws are contained in the Crimes Act 1900 in New South Wales, but the term consorting is not defined in the legislation. The High Court has described it as to associate or keep company with someone and said it involves seeking or accepting the association, but it does not require an unlawful intention or a criminal purpose. Our contemporary consorting laws in New South Wales were introduced in 2012 as part of a suite of legislation designed to respond to a series of very public incidents involving members of outlaw motorcycle gangs. Under the consorting law of 2012, it became an indictable offence for a person to consort with at least two people who've been convicted of an indictable offence and to consort with each convicted person on at least two occasions, after having been given an official warning by police in relation to each of those convicted offenders. That warning can be oral or in writing. And there are a few other additions to the law, and they're shown on the slide. So those new laws were reviewed by the New South Wales Ombudsman with a report published in 2016. And at that time, the Ombudsman was the independent oversight body for police complaints. The Ombudsman made a range of recommendations aimed at ensuring the laws did not have a disproportionate impact on vulnerable segments of the community, including young people, people experiencing homelessness and First Nations people. In relation to children, the Ombudsman recommended that children be excluded from the application of the consorting law, and also recommended a further review be conducted after the laws had been operating for a few years. So cue the Law Enforcement Conduct Commission, my apologies. So after a review, Parliament amended the consorting law in 2019 and required the Commission to review the operation of the amendments for 3 years. And I've summarised those amendments on the slide. They are the amendments that were introduced in 2019. In relation to children, the amendments excluded children under the age of 14 years from the consorting law and provided time caps for the duration of official consorting warnings, and for children that time cap was 6 months. So it's useful to understand the way police issue consorting warnings. This slide shows the total for each type of warning across all ages during the 3-year review period that we looked at. So a preemptive warning is usually issued to someone before police have seen them in contact with the person who they're warned about. These warnings are almost always issued in writing. They usually name more than one person, and they're usually accompanied by photographs of the people that are named in the warning. In our review period, preemptive warnings were most commonly issued by State Crime Command officers. They usually related to members and known associates of outlaw motorcycle gangs and other organised crime groups. The number of preemptive warnings is the highest of the various types because a preemptive warning is usually a series of warnings about a group. So one person will be issued warnings for multiple other members of the group, and each member of the group is similarly warned about multiple other people in the group. On-the-spot warnings are the type of warning most commonly issued by general duties officers. Our review showed that these warnings usually only related to 1 or 2 other people, and the primary record of these warnings is the COPS event created after the warning is issued. If an officer has their body-worn video activated, this also can provide an accurate record of the warning that's issued. While it's not mandatory for police to record warnings on body-worn video, New South Wales Police introduced some amendments to the standard operating procedures for consorting just following the conclusion of our review period, and these emphasised that body-worn video provides the best corroborative evidence of an interaction and is considered best practice. Subsequent or retrospective consorting warnings are issued after the consorting incident has occurred. These are less common and either occur after an officer has returned to the station and reviewed the conviction history of those they've had contact with during their shift, or after reviewing CCTV or other footage of individuals together. And a consorting booking follows an initial warning, and it's usually a notation in police records that a person warned has been seen with a convicted offender. Police don't always tell the person warned that they've been seen with a convicted offender. And the bookings are usually recorded in relation to, we saw that the bookings were usually recorded in relation to OMCG members and close associates when there was clear evidence that they've been together and the meeting was not coincidental. We found that these bookings often relied on CCTV or video footage from licensed premises. And in one case, we saw that a booking was based on photographs uploaded to the Facebook page of a particular chapter of an OMCG group. So our review looked at the use of consorting laws between the 1st of February 2019 and the 28th of February 2022. New South Wales Police provided us with records relating to every use of the consorting law in that 3-year period, both statistical information drawn from the COPS database as well as the detailed records and narratives for all 16,480 warnings issued in that period. We looked at body-worn video for a sample of incidents, focusing on footage of verbal warnings given by general duties officers. And we consulted 8 policing area commands, speaking with the commander, the crime manager, and proactive and high visibility units, as well as the commander and officers from the Raptor squad. We reviewed the standard operating procedures, training manuals, and other templates and instructional tools that were issued to officers about consorting, and we published a public discussion paper in October 2021 to seek submissions from the community and stakeholders, and considered all court transcripts for people charged with consorting during the review period. So in line with the amendments that were introduced in 2019, no young people under the age of 14 were warned about consorting. Additionally, no children were charged with consorting offences during the review period. So this slide shows a comparison of the results that we found during our review period and the earlier Ombudsman's review period. So the number of children over the age of 14 who were subject to the consorting law was far lower during our review period than the 2012 to 15 period that the Ombudsman looked at. During the Ombudsman's review period, 325 young people were issued with a warning and 251 were named in a warning, meaning that they were the named convicted offender about whom the other person was warned off consorting with. During the Commission's review period, only 48 children were issued a warning and 11 were named in a warning. And of those issued a warning in our review period, 12 were Aboriginal and 5 of those named in a warning were Aboriginal. That's just for that youth cohort. So why were there fewer children in our review period? Well, some speculation, but the exclusion of the under 14s from the legislation probably explains some of that drop. But it's also worth noting that the New South Wales Police Force introduced policy changes in 2019 to encourage officers to only use consorting laws on young people if they'd been convicted of a serious children's indictable offence. And, you know, the COVID lockdown might have also had an impact on the number of kids out and about, you know, consorting, whether, you know, for nefarious means or other. So that might have had an impact too. But more generally, the 2019 policy that police introduced also emphasised that the law was aimed at addressing organised crime. So while there were relatively few warnings issued to people under the age of 18 during the review that we looked at, we did identify some important issues in the way police used consorting law on children. In particular, issues relating to establishing a child's conviction history and the impacts of the predominant use of verbal warnings as opposed to written ones. Additionally, given the legislation was introduced with the intention that it be used to disrupt serious organised crime and gang-related activity, we asked, were police trying to disrupt serious organised crime in the way they use consorting laws on young people? Was there a planned approach to the use of consorting, or were the warnings issued simply because a young person was in the company of someone with a conviction for an indictable offence? And we asked these questions across the whole cohort, not just youth, but I'm just focusing on youth for today. So these queries helped us to get a sense of whether the laws were indeed being used to disrupt serious organised crime or had been taken up more as a day-to-day policing interaction. We looked at conviction histories for the young people who were issued warnings or who were warned about to try to understand the kind of criminal activities that police aimed to disrupt. So for the 48 children issued with a consorting warning, 4 of them had a conviction recorded against them when they were issued with a warning. And all of these 4 were 17-year-olds. Their convictions were for common assault, deal or traffic in a commercial quantity of prohibited drugs, and aggravated robbery. And it's relevant to note that a person doesn't need to have any conviction history to receive a warning, but any available conviction history is indicative of whether that person might have been involved in serious criminal activity or less serious offending. And as you can see on the slide, of the 11 people who were named in a consorting, young people who were named in a consorting warning during the review period, 8 did not have a conviction for an indictable offence. 1 was convicted of grievous bodily harm, 1 was convicted of supplying a commercial quantity of a prohibited drug, and 1 was convicted of robbery armed with an offensive weapon. And importantly, a person named in a warning must have been convicted of an indictable offence to be able to, for that warning to have been valid. So what we saw was none of the young people issued a warning or named in warnings during our review period met the policy threshold of having a conviction for a serious children's indictable offence. And this brings me to one of the issues we identified and also noted by police that we spoke to during our consultations. It can be difficult for police officers to establish the conviction history of a young person at the time they issue the warning, particularly if they're issuing an on-the-spot warning. We identified a number of warnings that named a young person for whom the Children's Court chose not to record a conviction, which kind of goes to that issue that you can see up there of people not having a recorded conviction for an indictable offence. And some police told us that even when they believed young people to be involved in criminal activity, they chose not to issue warnings because they couldn't be sure that that young person had a conviction. Our report also considered the difficulties police had in verifying convictions from other jurisdictions, which was one of the new things that were introduced as the amendments in 2019. We don't have time to talk about that today. It is quite interesting, but it is set out in our report, and so you can check that out. But during the course of our review, as we identified any warnings that looked like they might not be valid, we alerted New South Wales Police of those so that they could take action. We've provided police with a list of 57 warnings that appeared to be invalid for various reasons, and police said that they would remove those warnings from their system. So that's, I guess, one of the kind of benefits of having someone looking at this data at the same time that it was being exercised. And it's also worth noting that no prosecutions proceeded on the basis of invalid warnings during the review period, so that's good. So, noting the issues about the difficulty in establishing conviction histories for children, along with the difficulties relating to ensuring that interstate convictions met the threshold of being comparable to an indictable offence within New South Wales Police introduced a new case management model in late 2022, and this model requires a criminal investigator to verify the conviction status of all young people named in a warning. And it also introduced new guidance in the standard operating procedures, which you can see on the screen, which urges officers to seek their commander's advice before issuing a warning to children, and to also consider issuing a retrospective warning rather than one on the spot. So we saw that the warnings issued to people under the age of 18 were usually verbal warnings, and as such they contained much less information than preemptive written warnings. The body-worn video that we reviewed showed that many people, regardless of their age, did not know what consorting was when they were warned. It also showed that none of the verbal warnings contained accurate information about the duration of the warning, so for how long that warning was supposed to last for. The Commission recommended that if children are to be captured by the consorting law, they should always be given a written warning, even after any verbal warning is issued. Given the small number of warnings that are issued to young people, we don't think that this should be particularly onerous. And it may mean that a parent or guardian is more likely to be told of the warning and its consequences, and might be able to support that young person to avoid getting caught up in further consorting. The New South Wales Police Force told the Commission that consorting warnings have an important deterrent and diversionary effect for young people. However, if no written warning is issued, parents and guardians are likely to only find out about a consorting warning if their child tells them, or at the point of charges being laid. And this seems to detract from the possibility that being warned about associating with convicted offenders could, as claimed, have a diversionary effect. One of the trends we observed across all ages was that police, particularly general duties officers, often use consorting law to disrupt comparatively less serious potential criminal activity. This use differed in the specialist commands like Raptor, who predominantly had an intelligence-led approach and issued preemptive warnings. And it's important to note we did see some local commands use the consorting laws as part of planned responses to a spate of organised criminal activity like high-end car theft. Now, there's no doubt that some young people are linked to and commit serious criminal offences. However, most of the use of consorting laws against young people during the review period did not fit the definition of serious criminal activity. Our review of cops' narratives showed a pattern whereby general duties officers saw some people looking suspicious in an area known for drug activity, conducted a person search with a nil find, and then issued a consorting warning and a move on direction simultaneously. These interactions were not part of planned responses, but were the result of general duties officers on patrol taking action as they came across it. This raises a question about whether such use accords with the intentions that Parliament had for the consorting laws, and if not, whether such use ought to be prescribed. So this takes me to our recommendations. We made 13 recommendations in total, and I'll only take you through a few. We recommended that Parliament consider inserting a provision into the consorting law to limit its use to disrupting serious organised criminal activity. While an emphasis on using the laws for serious organised crime in police policy is useful instruction, it clearly doesn't have the same effect as legislation requiring the same. We also recommended that New South Wales Police require officers to record warnings on body-worn video unless there's an overriding operational reason not to do so. That recommendation was not accepted by police, but as I indicated before, the standard operating procedures do now note that recording the warning on body-worn video is best practice. Nonetheless, the Commission considers that making the use of body-worn video compulsory to record the warning, with a requirement that officers justify their reasons not to use it, makes for clearer instruction and tends to make it easier for a supervisor to address decisions made by police officers not to record that interaction. In terms of recommendations relating to the impact of the law on children, we recommend that Parliament amend the law to exclude anyone under 18 altogether on the basis of the difficulties establishing conviction histories in the field and concerns that the laws work against other statutory schemes and common law principles that emphasise diversion of young people from the criminal justice system. But as indicated earlier, if the law is to continue to be applied to young people, we recommended that children always be provided with a written warning. New South Wales Police Force disagreed with this recommendation. We recommended that police amend their standard operating procedures to require a justice link check before naming a child in a warning, or as soon as practical after a warning is issued, and if no conviction is recorded, to remove that warning and tell the person warned that warning has been removed. And New South Wales Police indicated that their introduction of using a criminal investigator to check warnings will address this. We also recommended that New South Wales Police amend its standard operating procedures and training to require officers to establish that children understand a warning issued to them, they know that it's valid for 6 months and understand the definition of consorting. Police are going to update their templates and written warnings to clarify that timeframe, and they have inserted a simplified explanation of consorting in their standard operating procedures to help police explain consorting to youth. So there was a change of government immediately after our report was tabled, so we'll wait and see if the recommendations for legislative change will be taken up by the Attorney-General. And just before I finish, I just want to say a special thank you to my research team, in particular Sandy Ty and Tom Millett, who are the primary researchers for this project. So thanks very much. Thanks everyone for listening.
Thanks so much, Justine. That was super interesting. So we've got a lot of time for questions. So does anybody have any questions for that? Yeah, just in the front.
I just had a bit of a comment on the written warnings for young people under 18. So, Liz, Youth Justice Queensland. So what we know about young people who become involved in the justice system, there's huge amounts of, there's big literacy issues, there are real concerns around developmental and cognitive impairments. And so what we also know is being able to understand court directions or anything in that written form, particularly when it's jargony, is actually really difficult for quite a large number of young people. So I was wondering about the considerations around that when making the decision about the recommendation that warnings should be in writing, and what the requirement might be around making sure that the language is still really accessible for young people.
Yep, we didn't go to what that warning should look like in detail, or how to make it clear language or anything like that. Clearly, that is something that we would expect, that it would be written in clear language. I guess the main thing for us was something as a record after the event for that young person to go, all right, I was issued a warning and this is what it means. They might be able to then seek some advice about what that means. One thing we did see in the body-worn video that we reviewed, a number of people, when issued warnings, not only youth but adults as well, appeared to be intoxicated at the time they were issued with a warning. And it raises a real question as to whether they're going to remember or really understood what was going on at the time they were issued with warning. And noting that this warning is not, it lasts for young people for 6 months and for adults for 2 years from the point that it's issued. We just thought that having some lasting record of the fact that warning was issued was better than no lasting record at all, given that consequence travels with that person beyond the moment.
Any other questions? There's just one here.
Hi, I'm Sophie from Aboriginal Affairs, New South Wales. I was wondering if you looked at or saw it being used concurrently with suspect target management plans?
We didn't. I don't think I can really say definitively whether we saw it on that. I'm sorry, I just don't have that research in front of me. We did look at, a range of. We looked at the way they were issued. What we noticed more prevalently was the use with move-ons and searches, but yeah, I'm sorry, we didn't look at whether each of those young people were also on a suspect target management plan or for adults as either.
Any other questions? Okay, great. Thank you so much,
Thank
Justine.
you.